What's up, everybody? Welcome into another episode of The Lawyer You Know, and we are going to break down some of the recent rulings by Judge Cannoni right as we begin trial number 2. Some surprises. I was wrong about a few of these guesses that I had of what she would do with some of the questions before her. We are going to talk about whether or not they can talk about the fact that the feds hired ARCA. We're going to talk about whether or not the defense can point the finger at the 3 third-party culprits that they want to point the finger at. And then we are going to talk about whether or not the defense can call their expert to explain just how bad and problematic this investigation was. All that and more. We're going to answer your questions. Let's get to it. So we are going to start out in the order in which I found out this information. And the first thing I saw was that the defenses, a lot of these have weird titles because they're not really normal how you would ask for things, but the defense's motion to enter evidence of lack of bias for ARCA. Basically, what that means is, can they explain to the jury, because the Commonwealth is going to say you paid them $20-something thousand, they are your witnesses, you prepped them, we have phone calls with them. Because the Commonwealth is going to present them as defense experts, the defense wanted the opportunity to present evidence that they were in fact hired by the feds. All of their testing and information was controlled by the feds and requested by the feds, and they only paid these witnesses to show up in court and testify. They talked to them for, a few minutes here and there, even prep them maybe, right? Whatever it may be, that's fine. Let's give the jury the full context here. Well, the judge has denied that motion. And this is a partial clarification to me because I don't know what the judge is going to allow the Commonwealth to put in and argue. Is she going to let him go full board like it seemed she was going to when she got mad at the defense not providing all the information about what they paid ARCA prior? She goes, I'm going to let you go full in on cross-examination of these witnesses and into the bias. So it seems like she is going to let the Commonwealth paint a pretty picture for them that these are defense witnesses. They're biased towards the defense. They're paid for by the defense, just like any other expert witness would be, which is not true. Doesn't bother me, right? We have expert witnesses in every case that we pay, we hire, and it's the appropriate evidence to put in front of the jury. But in this case, it's not true. And it seems like she's not going to let the defense clarify. Now, I haven't read this order. I just saw it on the docket that it was denied. So I would hope at the very least, she would allow the defense to say that they were hired by a third party, just like she did last trial, to do the testing, et cetera, and then let the Commonwealth talk about what the defense has done. I don't think it's the whole truth, in my opinion, but that is the order of Judge Cannoni. Number 2, the second order that I saw was her decision on Michael Easter. And I don't want to give away my thoughts on the third-party culprit decision, which we will finish with, but this to me was the biggest blow to the defense team. Actually, I shouldn't say that. ARCA, I think, is a huge blow. But if I was going to list them, the third-party culprit will be third on that list. I'll explain why when we get there. But this was a huge blow because to me, this is the case. The investigation is the reason this case has so much reasonable doubt. The investigation is the reason why we don't know enough information about these third-party culprits. The investigation is the biggest problem in this case. Okay? So the fact that we're going to read this motion and see that Judge Cannoni denies the defense the opportunity to call this expert, I think is a huge blow to the defense. They're still going to be able to argue problems with the investigation. They're still going to be able to argue the Bowdoin defense. So that is still there. But they are not going to be able to call this expert. Let's read why. So if you want to remember what my guess was as to what she was going to do, I hoped she allowed it, said this could even be some new law in Massachusetts. So many other jurisdictions allow it. It's totally appropriate. It's totally helpful, especially in a case like this. You don't need it in every case, right? If a cop doesn't read you your Miranda rights, you don't need to call an expert in to say cops need to read people Miranda rights, right? That's obvious. You can explain that without an expert. So I do understand that. I thought if she was going to say no and block this expert, it was going to be, we don't do that in Massachusetts. Never have, never will. I'm not going to be the one to allow this and change law in Massachusetts. So I'm just going to follow the rest of the cases and say, we don't need to do it. She added a little twist here that I thought was interesting. Memorandum of decision and order on the Commonwealth's motion in limine to exclude defense's expert Michael Easter's opinion of the investigation. The defendants have the right to base their defense on the failure of police to adequately investigate. In order to raise the issue of reasonable doubt as to the defendant's guilt in the minds of the jury. To support a so-called Bowden defense, a defendant may present evidence that certain tests were not conducted. I assume they will do that. Certain police procedures were not followed. They will absolutely do that. Or, should be or, that certain information known to the police about another suspect was not investigated. I can guarantee they're going to do that. In circumstances in which it was reasonable to expect that the police should have conducted such tests, followed by such procedures, or investigated such information. I agree with all that. An expert may, when appropriate, be used to support a Bowden defense on matters beyond the common knowledge of the jurors. So she finds a Massachusetts case, which the defense said they couldn't find. What does she say it stands for? Considering whether counsel's failure to use a forensic expert to testify about gunpowder residue and measurement of bullet trajectories deprived the defendant of a chance to assert a Bowden defense. I like it. She says the fact that they considered, that this court considered the fact that they could have had a forensic testify was an issue that they needed to discuss. She says that shows that even in Massachusetts, this can be appropriate. Sounds good so far. The role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience. Let me give an example of this. If we were to say it was 40 degrees outside because I looked at my phone and I was cold, do you need a meteorologist to come and tell you it was cold? No. You could. They're an expert. They're qualified, but you don't need it. Yet, we have a meteorologist testifying to all sorts of things in this case, maybe even that the ground was frozen. Even though Brennan admitted, I can just have lay people talk about the ground is frozen. That is basically the prototypical situation where you don't need an expert and the person calling the expert even admits it. Now, there may be some things, I can't remember exactly what the order was, that the expert may testify to, but taking away from this case, generally speaking, you don't need to call an expert to say the work week is Monday through Friday. That's a normal work week. You don't need an expert to say 12 o'clock is noon. You don't need an expert to say it's dark at night, right? Those are the types of things you don't need to call an expert for because a jury knows that themselves. They have personal experience with it, and you don't need to hire an expert and call an expert and make a big deal about it and reinforce things like that, okay? Thus, the first foundational element that the proponent of expert testimony must establish is that the testimony will assist the trier of fact to understand the evidence or to determine a fact at issue. Otherwise, qualified expert testimony is admissible if, in the judge's discretion, the subject of the testimony is not within, and this is very important, common knowledge or common experience of the trier of fact, and the testimony will assist the trier of fact in determining a fact in issue or in understanding the evidence. You can probably see where we are going here, right? In support of her Bowden defense, the defendant here seeks to admit expert testimony from Michael Easter, a retired agent of the FBI, to opine on law enforcement's failure to adhere to standard investigative policies and protocols in this case. More specifically, Easter's expert report indicates that he will testify that the investigation in this case was not reliable due to the lack of a secured crime scene, absence of a detailed crime scene log, or evidence of chain of custody. the failure to separate witnesses, and the premature categorization of individuals as witnesses, and potentially based on the failure to investigate other suspects and obtain their cell phone records. The court cannot find, nor has defense counsel cited, one Massachusetts case where an expert was permitted to opine on the general competency of police investigation. So while she cited the case up here about a forensic expert to testify about certain procedures, she agrees with the defense, which is what I guessed she was going to do, that we don't do that in Massachusetts. So she does partially agree and use the reasoning I expected if she was going to say no. I hope she would say yes. I thought she would say yes. But if she was going to say no, I always thought this would be her out. But she goes a step further. The lack of authority suggests that during all the jury trials where the defense has been inadequate police investigation based on Bowden, expert testimony has not been needed for the jury to be able to evaluate the reliability of the Commonwealth's case and whether any failure in investigatory steps are sufficient to create reasonable doubt of the defendant's guilt. Let's read the footnote here. The defendant cites the Commonwealth v. Wood, where the Supreme Judicial Court noted that defense counsel, through cross-examination and calling of its own expert, extensively challenged the adequacy of the forensic investigation conducted by police. The court acknowledges that some forensic matters are beyond the common knowledge of jurors and therefore appropriately explained by expert testimony. That is not what the defendant is seeking to present through Easter's testimony. I haven't read Easter's report. I wish I could. But she's basically saying if it's about bullet fragments and how you connect a bullet or DNA testing, there are certain things you need expert testimony for. But there are other things that are within jurors' common knowledge. Okay? Here's what I'll say. You could say that beating a suspect, bad. Cops shouldn't do that. Common knowledge. Yet, we have literally had expert testimony to go through what police protocols say. And in some of the trials I can remember, who allowed it? The judge. Who wanted it? The prosecution. They had cops testify to how you're trained, what proper protocols are, what proper procedures are. And I think that's appropriate, and that's fine. And that's what was violated. But when the cops refuse to do that in cases like this, the defense should be able to call an expert to go through that. Now, we'll talk about how Reed's team can still try to piece this together, but make no mistake about it, this is bad. I'll tell you what the major problems are with this too once we get to the end. Easter's proposed testimony concerns basic aspects of police investigation, which are within the common knowledge of a layperson. So first off, that's crazy. That's crazy to say that police investigations are common knowledge. Like maybe to people that watch true crime, maybe to cops, maybe to lawyers, maybe to feds, but do I don't know, Uber drivers know how police investigation works? Do doctors know how police investigation works? Does a teacher know? Do just normal people with normal jobs that have their own expertise and their own base of knowledge, do they know how police investigations are supposed to work? And by the way, a lot of people that think they know this stuff just don't, which is why we have experts. A lot of people think they're gun experts and ammunition experts, yet we still have a lot of experts explaining exactly how those things work. So I couldn't disagree more with the additional step. She says that everything Easter was going to testify to is common knowledge. Now, it's hard for me to with 100% certainty say that because I haven't read his report, but even based on what she cites, I would completely disagree that this is all just common knowledge and a juror gets it. Through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard procedures and practices and procedures, and can raise the issue of potential bias by police action or inaction, as counsel did effectively in the first trial. This leads me to what's she going to allow with the whole Proctor findings. She cites a Stedman case. Bowden defense supported by testimony elicited from police investigator that he did not conduct criminal history check on a third party, waited a week to interview him, and conducted an interview for only 10 minutes. In this case, reports would have been admissible to show that the police were on notice of a third party as a potential suspect, but that he was not investigated. Cross-examination used to elicit evidence that certain scientific tests were not performed during the investigation. Of course, they can do it on cross. So let's take a minute here and say, what can Karen Reed's defense team still do? Well, they can cross officers on it. They can get standard protocols, practices, and procedures, and they can ask the officers, you didn't do this, you didn't do that, isn't that standard protocol? The problem is, when you're doing it to the cops that broke protocol, they're going to downplay it. It was cold. It was snowing. Well, do you just throw out all your practices and procedures when it's snowing? Of course not. But they will make excuses. They will make it seem okay. They will downplay just how bad it was, which is what I would expect them to do. But that's exactly why you need an expert like Mr. Easter. And now the defense is not going to do it. They're still going to be able to attack it. No doubt about it. And they will attack it, just like they did in the first case. Also reading this, I almost think it's funny because Judge Cannoni, is like, this case is so obviously bad, the jury gets it. You shouldn't put stuff in solo cups, regardless of color. You shouldn't use Stop and Shop bags. Come on. Obviously, they should have tried to go in the house and investigate, and they didn't. This stuff is so common knowledge, common sense, logically backwards that even lay people can understand how bad this investigation was. That's kind of how this reads to me. That's kind of how I feel about this. The court finds that expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects, because it was so obvious. She didn't say that. I added that. Then another Commonwealth case, within the judge's discretion to preclude testimony touching on the alleged relationship between various interrogation techniques and false confessions. And then a Tolan case, not permissible for a judge to preclude expert testimony on commonly understood investigation methods because such interrogation techniques can be understood by jurors without expert assistance. What? What? I don't even get that. Like, to me, there are so many stupid things that we use experts for, including meteorologists, in my opinion. We all have the weather app on our phone, and we all know how wrong meteorologists are. This is exactly what you need. And let me take a second here. Is this done? Here, let me finish this, and then I'll tell you why this is so bad. The defendant is undoubtedly permitted to pursue a Bowden defense, so they're allowed to. And the court will give the jury a Bowden instruction if requested. However, jurors are perfectly qualified to evaluate the adequacy of the police investigation in this case without the assistance of expert testimony as proffered by the defendant. For the foregoing reasons, the Commonwealth's motion in limine to exclude the defense's expert Michael Easter's opinion of the investigation is allowed. So a couple things. First off, my comment still holds true that it's very rare for a judge to strike an expert because of their qualifications and expertise in education. And that's not what happened here. That bar is still lower than most people think. But to me, so somebody said this is reversible error. I don't know. I kind of think it's not in Massachusetts, since this would be the first time that they allowed it, even by the defense's own research. But this is such a big deal because we have talked so much about how the defense needs to streamline this case. The defense needs to tighten this case up. They need to keep it simple, stupid, right? The KISS method. And do you know how you do that? You cross here, you pick apart, you make your points, then you have an expert come and you do it all in one spot. You tie it in a nice bow, you put it in a nice box, and you hand it to the jury and say, this is the argument we're trying to make. Because when you limit the time you have for opening statements, closing arguments, and even some cross-examination, it's hard to really fully dig in and paint the picture for the jury. So what this does is it creates the environment, a toxic work environment for the defense, that they need to Every law enforcement witness take time to go through how bad it was, potentially be repetitive, make sure the jury understands, but maybe annoy the jury because the jury's like, we've heard that 50 times. Can we move on? Stop being so mean to these nice cops, potentially. And the defense is arguing that this is a bad investigation, but the cops know what their procedures are. The cops know what their protocols are. And the only person disagreeing with the cops is a lawyer. A lawyer's not a cop. A lawyer's not an expert on how investigations are to be done. That, to me, is the problem. It's going to be convoluted. It's not going to be streamlined. It's not going to be simple. And a jury could look at this and say, cops know police procedure, not lawyers. So who are we going to believe? All these cops that say no big deal, we had a reason that we did such a bad investigation and we changed police procedures. That is why, by the way, Kelsey, I just noted ARCA has 2 R's. I think it only has 1, right? So let's fix the title when we get a chance. Sorry, I just noticed that. Unless I'm wrong and it has 2 R's. This is a big deal because to me, this was a great addition and edit and change from the first trial to the second trial that I think was going to be a major bonus point giver to the defense. Ashley asks, why doesn't Bev allow the defense to say a governmental entity versus the feds split the baby? I don't know what she's going to allow, right? She's not going to allow it to say it was the feds. But that's why I said we need more clarification on exactly how she's going to let them announce what somebody else paid for versus what the defense paid for. Kathleen, how can she allow Colin Albert? Okay, hold on. I'm gonna wait for the third party before we get there. How can Bev say the jury doesn't need an expert to know about the proper police procedure, but they can have an expert telling them it was snowing? I agree. Can the defense use previous cases where these law enforcement officers may have done things properly to show deliberate incompetence in this case? So the defense should be able to, like I think it was Sarah Boone's case, right, where we had the Miranda issue where they could use the card. Just because it's police procedure doesn't make it case law. But if police violate their own procedure, same thing in Koberger's case, that's going to be an argument they make, then you should be able to argue that to the jury. So the defense should get whatever MSP's procedure is and show how they violated it. They should be able to ask the officers who testified. And they did last trial. You're supposed to record these interviews, right? And you just didn't. So it's things like that. You can use their own procedure against them. Amy Z, can the defense ask jurors how familiar they are with the process and procedures of law enforcement? Yes, they should be able to ask that in jury selection, I would think, especially in light of this order. If the Commonwealth witnesses testified that there were no issues with the investigation, can they open the door to Easter's testimony? I think the defense can ask for it again. Based on Judge Cannoni's order, I don't think so. Because you're met with the answer you're given, and you can say, here is your procedure, and they say, yeah, but we don't always have to follow that. And then the defense, again, if we're talking common sense, she's saying this is common knowledge. Obviously, they should follow procedures. So it's like, so then are they lying on the stand if they say it's no big deal? Because if they don't give you the honest, common sense, logical answer, I'm screaming. I don't know why I'm screaming. I'm sorry. It's a common comment that people think is annoying, and I get it. I don't try to scream. Sometimes I get a little heated up. But to me, if they just downplay it, you're stuck with that answer as the defense. And then you can argue it strenuously in closing argument. Nicole Riche hired former FBI investigator who now owns a private investigation firm as expert witness. It happened in the Melly case. We've done it in certain cases. There's plenty of cases across the country that allow this completely normally and regularly, and I think it's a great use of an expert. Ashley King, judges should be appointed by a committee of defense lawyers. The public isn't informed enough to make this decision, and if they were, we'd have no jurors because they'll all know too much about the system. So there is a judicial nominating committee that has defense lawyers on it. Some judges are former defense lawyers. A lot of times defense lawyers will write articles in local newspapers about it. People just don't know where to look for it and where to find it. And every jurisdiction is different. And I would implore you to ask lawyers in your area about what they think about judges. And then either if you vote for judges or you vote for the people that appoint judges, do your due diligence and use your vote. Beth, does it sound like the defense doesn't need an expert because even a layperson knows the investigation was garbage? I had the same thought, Beth. Amy Z, why train investigators if any Joe Schmo on a jury knows what it means to conduct a proper investigation? Why do we go through all of these continuing education and courses and time on the job and how long you've been doing this to make them sound like Mr. and Mrs. Expert Investigator if it's not important and everybody knows? Good day, Peter et al. Can you imagine a motion for reconsideration after the Commonwealth's case in chief? Depending on how the cops testify, yes, I can imagine it. Based on Bev's ruling in this case, Ashley just keeps getting me to call her Bev. Judge Canoni's ruling in this case, on a scale of 1 to 10, 1 being bad, how would you feel as a defense attorney going in front of her for a fair trial? So 10 is she's perfect, the best judge ever for me. 1, she's the worst ever. I would say a 3.5. 3.5. Maureen, uncanny parallels procedurally between Menendez and Reed's trials. First trial, mistrial. Second trial, new prosecutor, judge, also presided over the first trial, severely limits defense's arguments and evidence thoughts. I think that case was significantly worse in from one trial to the next. Not that the judge was worse, but the differences in the two trials. Has a judge ever boxed you in like this? And how did you work around it? So I've definitely had judges usually not disallow experts, but not allow me to make arguments I thought were appropriate and should be made or the way I want to make them. Yes, that has happened. Maybe not to this extent where I felt like there are some insanely pro-prosecution judges I've practiced in front of, like where I knew it was going to be bad. And I told my client, when we're talking plea deals, if you get convicted, you are screwed. It sucks, but it's true. So it does happen. We do feel things like this. It would not be abnormal, I wouldn't say. Now, her language in some of these orders, like when we're going to get to the third-party culprit order, is interesting. Canoni's baloney. Can they ask lay witnesses about police procedure to prove it's not common knowledge? So that would be funny, but my guess is that she would not allow a lay witness to opine on things like these, which would be interesting for her to explain why. Kimchi, clearly police procedure isn't common knowledge to Canton police. Ain't that a good comment? Lucy, what are your thoughts on filing complaints about this judge to the Commission on Judicial Conduct in Massachusetts? I don't ever like telling people to do stuff like that. You know, if she's not a judge in front of you and it's not your lawyer, I don't like people reaching out to the bar about lawyers that they watch on YouTube necessarily. Like if you don't like Hank Brennan and you go and try to report him and things like that, I'm not a proponent for that. I like going through the voting channels, either who votes for the judge or who votes for who appoints the judges. If the door is open, can they file a motion for reconsideration mid-trial to rebut the MSP testimony with the expert? They can file it, yes. Will it be successful? Unlikely. How frustrated would you be if you were in the defense in this case? I'm extremely frustrated, but I'm not an attorney. I don't know how it's warranted. Frustrated, extremely frustrated. But I will tell you, it is not that abnormal to feel frustrated with the judge's orders. This case is worse, I would say. Peter, did you see the defense has 9 law students, Harvard, Northeastern, volunteering to assist the team in this trial? More than 50 applied. So excellent. It's interesting. I did not see that. Bev, you didn't want to be the first, but if she's convicted, this will in fact be the authority people use in the future. We'll see. Can the defense ask ARCA? I guess it is 2 R's. I was wrong. Where they worked at the time they did the investigation/reports, can they sneak it in? You do not want to sneak something in that the judge said you can't do. That would potentially violate a court order. But you can absolutely dig into and make it absolutely crystal clear. I would ask over and over again until the judge stopped me. We didn't pay you to do this. We paid you to testify at a hearing. We paid you for a phone call we had, and we paid you to come and testify here at this trial. We did not test you or pay you initially. We didn't hire you initially. You didn't do any of these testings at our request, any of that. If this knowledge is so basic that everyone already knows, then why was it even needed for Proctor to have multiple IA hearings, wouldn't he have just been immediately fired? I think some of these are rhetorical questions. Police doesn't know the police procedure, but the jury should. Again, feels rhetorical. Is there a standard manual that each department has that could be used as a reference material to defend that the defense could reference? So usually you want to get that department's materials, because if you bring in a different one that's used like nationwide, if I was the cop on the stand, I'd say I've never read that. So I can't say it is or is not an authority on this issue, which is exactly part of the issue here. I would say I only know our procedures. Sorry, Mr. Jackson. So they would have to use their procedures. So can the defense now ask, again, for the Birchmore stuff, to grill the common officer on proper procedure versus not comparing the cases? I think they're going to have to stick to the procedures that were used. Can they ask if an insurance company hired ARCA? I would ask to rule it out. It wasn't Miss Reed's car insurance. I would ask to rule that out. And I think you have a pretty good reason for that. Vicky, would this be a strong appellate issue? I want to say yes, but I don't think so in Massachusetts. I don't think it's normal to overturn something that's never been allowed before. But maybe this will be the case, because this is not a normal investigation. This is so bad that this feels like the perfect case to allow this type of expert. Could the defense call the person who fired Proctor and gave the press release to ask how the investigation should have gone? No. But what about comparing old cases of Proctor to show he may have deliberately done things wrong in this case? So I think they should be able to get into the past incompetences of Proctor and other investigators and how they commonly and routinely don't follow police investigation, especially when a potential third-party culprit is connected to law enforcement. I still think they should be able to argue that. If police procedure is common knowledge, then how come MSP or CPD did not follow this procedure or even acknowledge the blatant disregard of basic procedures in regards to this case? I think those are all incredibly good questions. Can they add a question to potential jurors if they know police procedure in the voir dire? You guys are smart. I think that's a good question. I would ask them about it. Now, it's not going to change the ruling. If all these jurors are like, nope, I don't. But if they do know, I don't think the Commonwealth's going to be like, we want to strike that witness because they're familiar with police procedure, right? That would be embarrassing. All right, let's get to this last motion here, or order, I should say. And then I will answer more questions as they come along. All right. Memorandum of decision and order on Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. When I saw people posting this on Twitter and they said, judge denied the ability to make the third-party culprit argument or present that defense, I was like, whoa. Even Kelsey texted me and I was like, whoa. One of the headlines. But that's not quite what it is. And to me, my overarching thoughts is I wouldn't quite call it a blessing in disguise, but I think it's potentially NBD for the defense. No big deal. I really think that, because what I think, and this is just one man's opinion, what I think the most important part of, I'm like sweating because I'm starving. Does that ever happen to you? Get starving and then I start sweating. I think that they can still get 95% of the effectiveness of the third-party culprit defense even after this order, and let's figure out why. The Commonwealth has moved to preclude the defendant from raising a third-party culprit defense. The defendant has alleged 3 potential third-party culprits, Brian Albert, Brian Higgins, and Colin Albert. For the reasons that follow, the Commonwealth's motion is allowed in part and denied in part. And I will say, I disagree with this. I think it makes no sense to split the baby like this, that Judge Cannoni did it. I don't get it. And I don't know why she did it, but I don't think it's going to matter in the end. Just my opinion. The opportunity to present a third-party culprit evidence is guaranteed by the Due Process Clause of the 14th Amendment because it is rooted in the right of criminal defendants to a meaningful opportunity to present a complete defense. I couldn't agree more, Judge Cannoni. Couldn't agree more. A defendant may introduce evidence that tends to show that another person committed the crime or had motive, intent, and opportunity to commit it. However, the defendant's latitude to introduce such evidence is not boundless. The defendant's ability to mount a third-party culprit defense is not without limits. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that it has substantial probative value and will not tend to prejudice or confuse the jury. So substantial probative value and not prejudice or confuse the jury. Proffered evidence must have a rational tendency to prove the issue that the defense raises and the evidence cannot be too remote or speculative. Again, I would tend to agree with everything she said so far. Let's start with Colin Albert. Is she going to allow this? As to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had motive, intent, and opportunity to commit this crime. So she's putting her juror hat on basically and saying, no good. Sorry, I didn't mean to put this up yet. Is there a limit on the number of attorneys a client hires? Not necessarily. You can't make it create a problem with trial, procedure, confusion, distraction, but there's not really a limit. I meant to put this one up. That's a good point. I don't know if it's just been allowed, so it's never been appealed, and that's why it's not case law. That's a good question. I don't know the answer to this in Massachusetts. Canoni's baloney. Okay. The evidence of opportunity is wholly inadequate. There is no evidence that Colin Albert was at 34 Fairview when the defendant and Mr. O'Keefe arrived at home. And this is the problem, again, with the investigation. It's like, Judge, I can't prove this because the investigation was so bad. So therefore, because they did such a bad investigation, she's not going to allow the argument, which is what I think. If you agree that the Bowden defense is so bad and the investigation is so bad, let them make this argument. Because the fact that they don't have what you said they need is because the investigation was so bad. Third-party culprit evidence properly excluded where there was no evidence of third party had means or opportunity to commit the crime, and evidence of motive was speculative and too remote. Evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. Wasn't the best evidence, but okay. As to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and Colin Albert had thrown beer cans at O'Keefe in the lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial. Even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate the third-party culpability. And the footnote is, to the extent that at the upcoming trial, the defendant would offer hearsay testimony to support the claim Colin Albert's feud with O'Keefe to be admissible, such evidence must be otherwise relevant, not to tend to prejudice or confuse the jury, and there must be other substantial connecting links to the crimes. So that footnote right there, if I'm the defense and I read that, I would say, so you're saying there's a chance. So you're saying there's a chance, Judge. This is not over. So potentially they can still elicit some of this testimony, which to me is interesting, really interesting. Is she leaving the door open? Fact of tensions between the neighbor and victim was not indicative of the neighbor's motive to kill, and the defendant offered and produced no evidence suggesting that the neighbor had the opportunity to kill beyond that possessed by any neighbor. Moreover, the theory that Colin Albert is the third-party culprit because he had scraped knuckles at some point after O'Keefe's death, had been seen in a video drunkenly taunting others with no connection to O'Keefe, and apparently was not named in the police report, is speculative at best. Third-party culprit theory that the victim was shot by unnamed rival drug dealer based on rank speculation was properly excluded. evidence that rival gang members lived near the shooting and were involved in a feud with victims was not sufficient to support the third-party culprit defense, where there was no evidence that they had been nearby at the time of the shooting, and the theory was speculative at best. Allowing such feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth and would only serve to confuse the jury. Accordingly, evidence that Colin Albert is a third-party culprit is excluded from trial. The Commonwealth's motion in limine is allowed. Sounds like she's saying unless you can bring a little bit more. Kathleen asked, how can she allow Colin Albert to be a third-party culprit in the first trial but change her mind for this one? His name was left out of all police reports and he wasn't interviewed for like 18 months. How is that possible? So that doesn't make him a third-party culprit, but I agree that's fishy. And they still can, to try to prove, the conspiracy, if they want to go that route. She is allowed to change her mind, especially after seeing how the evidence was presented in the first trial. Because the first trial, if you remember, she said, let's see how it all comes out. So I do get that to a certain extent of why she changed her mind, or that she could change her mind. But here's why I think it's not that big of a deal. Well, let me wait till we read the rest of it. Who in the chat can remember what I think the most important thing and reason for the defense to be able to use a third-party culprit defense is, especially in this case? If you can remember, if not, no big deal. It's not a test. But if you remember, throw it in the chat and I'll put it up on the screen. What do I think the most important thing is for a third-party culprit? Is it to prove beyond a reasonable doubt that they did it? No. What is the reason? All right. Brian Albert and Brian Higgins. As to Brian Albert and Brian Higgins, the defendant's proffer is barely sufficient. Barely sufficient. So one of the major reasons she said Colin Albert can't be a third-party culprit is because he wasn't at the house. You can't prove he was at the house. Well, that one very big problem on Colin Albert, you can check that box for Higgins and Brian Albert. So why did they barely meet the standard? And even if they do barely meet the standard, guess what? You still meet it. That's like saying, I barely graduated law school. It's like, I graduated. And last I checked, if you graduate law school, you're a lawyer. I didn't barely graduate, by the way. But if you barely graduate, you're still a lawyer. If you barely pass the bar, you can practice law. Like, it's still sufficient. It's unnecessary to throw language like that in. Absolutely unnecessary. It's annoying. But she does it. And the history of the first trial casts doubt on the seriousness of the claim. However, to protect the defendant's right to a fair trial, yeah, that's important. We need to do that. And in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as it did the first trial. The defense counsel are ordered not to mention potential third-party culprits in opening. So this is exactly what I guess she would do. So while technically I was wrong, if we look at the totality, because she didn't allow it with Colin Albert, I was actually spot on, and the judge did pretty much exactly what I expected her to do when it comes to Higgins and Albert. So you can't use it in opening statements, but counsel will be allowed to develop the evidence at the trial if possible. And counsel may seek appropriate instruction if warranted after the evidence is concluded. The court notes, as the footnote, that the defendant at the first trial under an identical order did not seek an instruction on third-party culprit. Though the court may ultimately exclude the third-party culprit evidence or counsel may abandon the theory, that does not mean that the defendant cannot offer evidence to show the inadequacy of the police investigation, provided that the proper foundation has been established. So pretty much the same exact order and way we're going to do it as the first trial. It is hereby ordered that the defendant is precluded from raising a third-party culprit defense against Colin Albert, is culpable for John O'Keefe's death. The Commonwealth's motion is allowed as to Colin Albert, but the defendant is not prohibited from raising a third-party culprit defense. Realize that their words are important, definitions are important. They're not prohibited. It's not allowed yet, but they're not prohibited from going after Higgins and Albert, Brian Albert. Counsel cannot mention the third-party culprits in opening statements, but he will be given the opportunity to develop the theory throughout relevant, competent evidence. The Commonwealth's motion is denied as to Brian Albert and Brian Higgins. So we'll see how they narrowly tailor that opening statement, right? We'll see. So let me see if you guys got this right. Elizabeth said to give the jury someone to blame. Ding, ding, ding. Hannah also said it. Lion also said it, as per my dad. And a bunch of you said it in the chat. Well done. A+ on the quiz. That wasn't really a quiz. And that's why, to me, this is still not that big of a deal. ARCA, big deal. I wish they would have been able to know the full truth. The investigation expert, big deal. I wish they would have been able to nicely package that for the jury and explain it to them. This, NBD, because they still have someone to blame. Brian Higgins and Brian Albert. And some people asked, why did the defense give 3 names? Why not just pick one? Well, they gave Judge Cannoni the opportunity to split the baby, and she did. And they're still going to give the jury someone to blame. And let me take it a step further. Let me take it a step further. I know some people cannot understand it. I don't think the bang bang video and that stuff's going to come in this trial. I don't know. But Colin Albert's a younger dude. And it is possible for a jury that doesn't know any of the players involved. It is possible for the jury to feel bad for Colin Albert. It is. They could have a son his age, a brother his age, a nephew his age. And they could be like, what douchebags going after a kid? And that is being removed from the defense. I don't think that many people are going to feel bad for Brian Albert and Brian Higgins. I don't. So I think I'm not going to go as far as to say a blessing in disguise, but I don't think this is as big of a deal as it might have initially felt like with the shock and awe you may have felt, because I think she left the door cracked open for Colin Albert, but it's wide open for Brian Albert and Brian Higgins, and we'll see what happens. Is it possible that there is no case law because it was never appealed if the trial courts allowed it? Yes. A state with so much alleged corruption doesn't allow expert on police procedures. Ain't that funny? Sandra, Pita, I was listening to you and your dad, and you said it would be sus if Judge B denied their expert. Where do you stand now? I hate it. I hate it. I think it's wrong. I think she shouldn't have. But I said, every time I've said it, she had an out because there's no case law really forcing her hand. How is it legally okay for the judge to serve as finder of fact regarding third-party culprits in this motion? Isn't that for a jury? So if it goes to a jury, it would be for a jury. But there is a standard and a bar, just like expert testimony. She is the finder of fact. Are they qualified? If they don't meet that bar, then it can't even go in front of the jury. She is the gatekeeper. And that is one of the ways in which she is when it comes to the third-party culprit evidence and whether or not there's enough to cross that bar, like she said. Lola, the judge's ruling sounds similar to the language Morrissey used in the hostage video. Isn't that funny? Isn't that funny? Huh. Well, folks, I need to go eat. I am starving. So make sure everybody hits that like button. Make sure you guys are subscribed to our page. There's a lot more going on this week than I initially expected, but that's all we got for this one. So until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.